Presiding Judge and Judges of the Court of Appeals of the State of North Carolina. Oh yes, oh yes, oh yes, the Court of Appeals is now in session. God save the state and this honorable court. Please be seated.
Good morning, everyone. Welcome to the Court of Appeals. I'm Judge Donna Stroud, and our panel today also includes Judge Robert Hunter here on my right and Judge Chris Dillon on my left. And we have two cases for argument this morning. And let's see. So we will begin. I believe the Young case is the first one for argument. And let me know if you'd like to reserve time for rebuttal. We've got our little light system here now, which we might know how to use properly.
Okay.
And we're going to try.
So I would probably like to reserve about 5 minutes.
Okay, very good.
May it please the court, my name is Barbara Blackman, representing Jason Young. Quote, "This case is solved. Jason Young brutally murdered Michelle Young in the early morning hours of November the 3rd, 2006, in the bedroom they shared at 5108 Birchleaf Drive," unquote. That's how the state began its closing argument at page 5893. And the language should sound familiar to you, because it's the language that appears in the wrongful death and child custody complaints. Those two complaints and the default and judgment which occurred in the wrongful death case happened a year before Mr. Young was indicted and arrested, when the state's circumstantial case only got it a hung jury favoring acquittal. The state turned to this inadmissible evidence in its attempt to gain a conviction. And if this type of evidence is admitted for what will apparently be the first time in the country in a homicide prosecution, I think that it's simply going to open the door to the pursuit of civil litigation before indictment in order to manufacture evidence for use in an eventual criminal trial.
The state tends to say that this is something that should have been objected to. What is your view on that subject?
There was one objection lodged, and that was the 403
It has to be
objection.
specifically objected to, and the statute would need to be cited. What is your view on that?
That is the subject of the motion for appropriate relief. I think that there did need to be additional objections made, and as counsel stated in the affidavits attached to that motion, it was due to their failure to conduct the necessary research rather than any strategic decision-making that led to their failure to make the appropriate objections.
Does that meet the standard of deficient performance?
Clearly, when you are confronted with an evidentiary problem that you have not faced before, prevailing professional norms require that you conduct the investigation necessary in order to make a tactical decision as to how to approach that evidence.
But isn't the state given a wide, in North Carolina we have a very wide latitude on cross-examination. And isn't this material, if he takes the stand and waives his right against self-incrimination, doesn't the state have a right to discuss these civil matters with him?
Well, Mr. Young obviously didn't testify at this particular trial. When the state had an opportunity in the first trial to have sought to impeach him on these bases, the state didn't do so. What they did, and the jury is aware of this because that trial testimony was admitted, the prosecution impeached him with the fact that he had not made a statement to family, friends, or police.
Well, let me ask my question a little differently.
Yes.
When he testifies in the first trial, doesn't he waive his right of, isn't that a waiver for all future trials as well as the first trial?
It's not a waiver to be impeached with inadmissible evidence. Clearly Hunt states that the state cannot reach out to incompetent evidence in order to conduct impeachment. I want to return just briefly to the initial question that you asked. There was no need for a specific objection as to the violations of the statutory mandate. Those are preserved as a matter of law. And so to the extent that this evidence violated Section 149, as well as the prohibition against expression of judicial opinion, no specific objection was needed.
Tell me why this would rise to plain error.
It rises to plain error because It is the type of evidence which has a probable effect of the jury, which is why statutes and case law prohibit it. The jury basically was told that Mr. Young's acquittal constituted an admission of this crime, and they were told that a judgment had entered declaring that he was the killer. When you're proceeding in on an alibi defense, being told that is clearly contrary to that defense and will impact how the jury is resolving this case. All we have to do, I think, again, is look at that first trial in which the identical circumstantial evidence was presented. This particular body of evidence was not, and that jury hung 8-4 for acquittal. So I think we can say with confidence that this evidence did have a probable impact on the jury.
Would you say the jury wasn't the jury instructed, however, that they weren't to consider the civil action as evidence of his guilt in the criminal trial?
No, there is absolutely no place in the instructions given to the jury that advised them of such. What that instructions basically did was set out the timeline of how it is that a civil case proceeds and how this particular civil case proceeded. It ended, both of the instructions given ended with the language, the entry of a civil judgment is not a determination of guilt by any court that the named defendant has committed any criminal offense. What the state is asking you to do is read that as saying, you, jury, may not consider the entry of a judgment that Mr. Young killed his wife as proof of guilt. And there's simply nothing in that language that can be interpreted in that way. At the time that this evidence was admitted, the jury wasn't told it was being admitted for impeachment uses and that use only. And in these instructions, it likewise wasn't told that. The words, you may consider this in assessing truthfulness, you may use this in assessing credibility, absolutely nowhere appear in that instruction.
In the normal course of things, every murder, of course, could generate a slayer statute or wrongful death case. And in the normal practice, as I understand it, if someone is represented in that situation, they move for a stay until the criminal matter is resolved, don't they?
Well, Mr. Young...
I realize you don't practice in the civil
I don't
court
practice in the civil court.
But
I mean,
is
that would
the
seem
way
to
it's
be...
normally done to prevent some problem with the right against self-incrimination?
Well, I mean, it's very unusual for a wrongful death action to be filed before the commencement of criminal proceedings. Mr. Young was, as the clerk told the jury, Mr. Young was not represented by counsel in that action. So no action was taken by him at all. In that regard, clearly the judge in the wrongful death proceedings had the option to either enter or not enter judgment at the time the plaintiff asked for entry of judgment. And the jury was told that in the instruction, that the judge can enter, meaning can also not enter. So, I mean, unless there was some pressing need at that time for the judgment to enter, certainly the judge himself could have delayed entry of judgment.
It was the same Judge Stevens that entered the civil judgment that gave the instructions in this case, was it?
That's correct, and the state elicited evidence to that effect. The jury was quite aware that Judge Stevens, after reviewing the contents of the motion for entry of default judgment, went ahead and chose the option of entering judgment. The state also argued that there's no way that the jury would have taken the default as meaning an admission because the instruction advised them that a default judgment will enter whether the evidence is true or not. However, the state clearly utilized this evidence in order to show that the allegation in the civil complaint and the default itself was more likely true. And they did that by their elicitation in violation of Section 1149 of the contents of the motion for default judgment by having the clerk recite that attached to that pleading was an affidavit by the lead investigator in the criminal case, as well as photographs from the Hampton Inn, a shoe tread design, a photograph of shoe prints, and so on. and that was done in the context of the hearing on the motion for entry of a default judgment. The judge considered that evidence and opted to enter. So clearly, the thrust of all that the state was doing here was to establish to the jury that the allegation in the civil complaint was more likely true than not, and that the admission by default was more likely true than not.
But isn't the jury instructed on a reasonable doubt and not a more true than not preponderance of the evidence?
Certainly it is. But the point here is that because the judge didn't rule that this was being admitted for impeachment purposes only, that appears nowhere in his ruling. The instructions at no point stated this was for impeachment use only. That means that all of this was substantive evidence for the jury to utilize in determining guilt. Whenever evidence is admitted without any express limitation, as this was, and admitted without a trial court ruling as to the reasons why it is being admitted, then this court must deem it to have been admitted for substantive purposes as well.
What is fundamentally unfair about admitting evidence like this if it's not objected to? I mean, I can understand that this is a novel application of civil proceedings. Normally you do the reverse. A criminal proceeding is used in the Slayer statute or in a wrongful death case. But what's so fundamentally unfair about that would rise to plain error here? I mean, if the attorney representing Mr. Young had objected, I can see how it would have had to have been excluded. But if he fails to object, what's so fundamentally unfair about taking this default into consideration?
Well, first off, I mean, there were objections raised. I mean, we did have an objection made at the time the clerk recited that a judgment entered. We do have the 403 objection, which went across the board to all of the evidence. We had another 403 objection being raised when the clerk offered her opinion that Mr. Young could have proceeded pro se and presented whatever evidence he wished to had he participated in the civil action. So there are objections being made to this evidence. But it's fundamentally unfair because, number one, civil proceedings are governed by a different rules of evidence. In civil proceedings, the defendant can be compelled to testify, whereas he cannot in a criminal case. We've got preponderance of the evidence versus reasonable doubt.
I mean, he can assert his Fifth Amendment privilege in a civil case just as well as he can in a criminal case.
But he can be compelled to testify in the civil proceedings. There would also be...
If he asserts his Fifth Amendment privilege, he can't be compelled to try.
But the prosecution in the criminal case can't put a defendant on to then assert his Fifth Amendment privileges.
Which is then an admission for civil purposes of liability.
I mean, this type of evidence, when we're talking, I mean, we've got an alibi case here. And so the only issue is, who is the killer? Is Jason Young the person responsible for Ms. Young's death? And, you know, it seems fundamentally unfair for the jury to be advised that a judgment has entered declaring him to be the killer. And it's fundamentally unfair for them to be told that by failing to answer the complaint, he has admitted that allegation, that factual allegation in the complaint that he, in fact, is the killer. I mean, this is going totally against the defense that was proceeded upon at trial. So, I mean, there's certainly enormous fundamental fairness in that information having reached the jury. And we've also got the problem...
Was the judge made aware of the statute at all?
No. He was not aware of it.
It was never brought to his attention at the trial?
That was never brought to his attention. But this is a statute that has been in existence for decades. I mean, there has been a very long-standing prohibition against use of civil proceedings in criminal trials as proof of a matter alleged or admitted.
What about the state's argument that they weren't really using it for that purpose, but simply just to impeach his trial testimony by showing that he was silent before he was given an opportunity, or he chose not to respond, as if somebody didn't respond to police questioning but later decided to testify and use that to impeach the witness?
Well, as I said, I think that by eliciting the contents of the motion for default judgment, the state is making the point that the allegation in the complaint is in fact true, and that the admission by default is in fact true. I mean, that's fundamentally different than saying Mr. Young didn't answer questions by his friends or family or police, none of which, by the way, was usable as substantive evidence, as this indeed was. We have a number of legal grounds advanced on which the court can reverse. I frankly think that the simplest one for the court to address is plain error hearsay. As Brandis and Brown discuss, this type of evidence doesn't meet any hearsay exception. It's clearly not 803, 6, or 8 evidence, as the state argued in its brief. When you look at those particular portions of the rules of evidence, you can see that a civil complaint, for example, is not a record or data compilation of acts, events, conditions, opinions, or diagnoses made at or near the time by a person with knowledge. You know, likewise, a judgment is not a report or statement of data compilation of the activities of an office or agency. And that's why Brandis and Brown conclude this evidence simply doesn't meet a hearsay exception. Given the nature of the evidence and its probable effect on the jury, I think that's the simplest way for the court to address the issue. Now, we clearly also do have the violation of the statute on expression of judicial opinion. We also have the violation of Section 1149. We have relevancy problems because this judgment is not independently relevant in the case, as it might be in a situation where the existence of a judgment is an element of the crime. That's not what we have here. We also don't have a judgment capable of having any res judicata effect. So we've got relevancy problems, and we clearly have Rule 403 problems. I mean, this is evidence which invites the jury to misuse it. We have evidence that's going to confuse the jury as to what it should do. And we have a cumulative presentation of evidence. If the point here is simply one of impeachment, the jury has already heard over and over and over again that Mr. Young failed to make any statements until he testified at that first trial. So on all of those bases, reversal is required, and all of them add up to the conclusion that we've got a verdict here that we simply cannot have confidence in. We also, as I addressed in the MAR, do have concerns about the representation that Mr. Young was afforded as to this issue, which again is undermining the reliability of the verdict and undermining our confidence in this verdict. So in the event that the court rules that sufficient evidence was presented to withstand the motion to dismiss, then certainly on the basis of this evidence, Mr. Young is entitled to a new trial, so that we do have a verdict in which we can have confidence in.
Could you talk a little bit about one of the evidentiary matters which was admitted, which was the excited utterance of the child? What is your view about whether or not that was offered for the truth of the matter asserted?
Well, it was clearly offered for the truth of the matter asserted. I mean, if the court rules that evidence meets a hearsay exception, then it is coming in substantively.
What truth was being asserted? She just said, Mommy's got blood or whatever, that was already proven. Wasn't it? I thought they were just offering just to show that she was at the scene.
Well,
what was the truth that was being asserted?
I mean, clearly she is at the scene in the sense that the scene is the house. But what the state wanted to establish is that she was an eyewitness to the killing.
But she didn't say, I saw Mommy get killed. That's not what she said.
Well,
So they weren't trying to prove
what the state is asserting is that she's using language consistent with her age. That in saying, I saw my, Mommy got a spanking for biting, that she's describing what an adult might say, I saw my mother being beaten.
Well, why is she a competent witness at all to testify, given her age?
Although the defense raised a competency objection to the testimony, the trial court never addressed competency issues. But certainly we have to be concerned about that in light of the remainder of the statements that Cassidy Young made. I mean, very shortly after having given that particular set of statements and engaging in the conduct, Cassidy Young also said mommy is on the bed with animals, there was a cow, mommy fell. So we have in the totality of the statements that Cassidy made some concern about whether she is describing an event which she witnessed or whether she has an active imagination. The state, I think, in the briefs did not address either of the other two bases upon which the trial court ruled, which was present sense impression and residual hearsay. And I think I've set out in the brief as to why these particular statements didn't meet either one of those exceptions. If the court has no further questions, we ask for vacation of the conviction or alternatively a new trial. Thank you.
May it please the court, I'm Dan O'Brien, and along with my colleagues Amy Irene and Robert Montgomery, I represent the state here this morning in this case. I'll be covering issues 1, 2, and 3 in the MAR. Ms. Irene has issues 4, the child statements and sufficiency, and Mr. Montgomery handled issue 5. Now, as to issues 1, 2, and 3, the admission of the civil matters, the defendant is simply wrong in his position that North Carolina General Statute 1-49 bars civil matters from being used in criminal cases. But just not so. The very annotations of the statute have a number of cases where it was held error, have a number of cases where it was held proper. It's held error in the case where the civil matters are used to prove the very same facts to prove in this criminal case, the same facts that were alleged to prove in the civil case. When the proponent of this material says, see, to the jury, see, this has already been adjudicated. That's what's improper. But the cases say that it's completely proper, fair, to use civil matters if they prove something else relevant to the criminal case other than that impermissible purpose. McNair is the case particularly because that case establishes the test for whether a civil matter can be used in a criminal case.
What was the purpose the state used it?
The purpose was, and this gets to relevancy as well, is to show that instead of saying to the jury, see, this is already adjudicated, the state is saying, what? He's saying he's giving this explanation now in his trial when he had every reason in the world to have said that before. He chose to be silent when he had all of his assets on the line, $4.2 million in insurance benefits and custody of his daughter. He testified that I couldn't fight that battle, the custody battle, because I didn't have money. And so it completely discredits his statement that to recognize that he did not even contest these civil matters.
But I'm a little at sea here about why that is of interest or relevance to a criminal jury trying to make a determination of who killed Mrs. Young. I mean, so what if he decides not to allow the default judgment to go in? How does that fact, one way or the other, have any impact on whether he killed his wife or not? I mean, people may be negligent in their affairs, and certainly this person was under some distress. So, I mean, I just don't understand how the jury takes that piece of information and is able to weigh how that impacts on whether he could have returned to Raleigh and killed his wife and gone back to the Hampton Inn, or this whole this circumstantial case is, I mean, the purpose of it isn't the purpose of it for the state to say that he has admitted liability in the civil case and that he is guilty in the criminal case, because the accumulation of both facts are the same, and it's more likely than not that he did it, and now we want you to take that more likely than not finding made by Judge Stevens and apply it here, because if he remains silent or if he doesn't talk to his friends, there's a pattern of behavior here which is indicative of guilt.
Absolutely not. The state never admitted it for that purpose and never argued that.
What was the purpose it admitted it for?
What they argued repeatedly is this is a case where defendant in his first trial testimony gave this sort of simple explanation for why, although he was at the hotel all night, that's what he says, for why the key card used wouldn't show that he was at the hotel. And he kind of gave this.
Does a civil case have to that?
Because if that was all he had to say, if that was his explanation for why he was really somewhere else, he would have said that when $4.2 million in custody of his own child was on the line.
But that's precisely.
And so it discredits
But don't
his
you have
the
to
state.
prove that fact beyond a reasonable doubt in the criminal case? And in the civil case, it only has to be proved beyond the preponderance of the evidence.
Right, and the judge's instruction, I mean, Judge Stevens was keen on this. I think I think you can infer that he knew directly about 1-149.
Well, let's not infer. Does he say it has to be what presented to him, was it?
No, but he says defendant's objection here was Rule 403, which requires an abuse of discretion, which requires a showing that this was manifestly without reason what the trial court did in admitting this.
Well, isn't ignoring the statute manifest unreason?
The court didn't ignore the statute at all in the defense counsel. Even if they didn't know about it, even if we accept that as true, an objection under 1-149 would have been fruitless. Judge Stevens was all over it, and he said, this is how, and this is what he said. Since this will require the jury to fully understand and appreciate the limited nature in which the evidence can be received, and since this is a situation in which a court has made some declaration, which declaration did not find defendant guilty of any crime, I need to make sure the jury understands the law relating to a civil action. And I'll give this instruction. He's prepared beforehand a written proposed instruction and hands it to the attorneys. Is there an objection from defendant? No, because the instruction is correct. And then he gives the instruction. And the content of the instruction is, these civil complaints were filed, defendant was notified, he did not respond. Entry of default means that the allegations are merely deemed admitted, whether true or not. There's a low burden of proof anyway in civil matters, and an entry of civil default judgment is not a determination of guilt by the court that the named defendant has committed any criminal offense. And then when you take that, and then he repeated that instruction again in the final charge to the jury, in addition to instructions, you, jury, are the sole judges of credibility. You are the sole judges of the weight of evidence.
Did he ever tell them how they could use that evidence? Were they ever instructed, or that's what they're arguing, that the jury was never told how they could use that evidence for impeachment purposes or whatever?
Right. Well, it's not really impeachment because we don't have a defendant testifying, so it's really just to discredit his statements. We're not really into the impeachment category like the State v. Hunt case or anything. But, I think
If
the jury...
it's not impeachment, is it substantive? I mean, is there another kind of evidence?
Well, it's just. I guess it's evidence that discredits the value of his statement. It just undermines his statement, so it's relevant.
So the state put on a statement and then was able to put on evidence to say why that statement wasn't right.
Right. Defendant has committed himself to this story, about the key cards and everything. If that's all he had to say, he would have said this before clearly. So you can't believe this now. In fact, the state argued and put on evidence that, and defendant even said it in his statement. I didn't want to answer the civil matters because I didn't want to have to give a deposition. I didn't want to have to be psychologically evaluated. And they talked about that at trial before the jury. It's in defendant's statement. That's why he didn't. And so the inference is he waited until the criminal case came around and he got all the evidence that the state had against him. He knew exactly what he could say to try to fit his testimony into the state's evidence. You see, he waited until he got all the discovery, and then he can bring out this big lie, essentially. That's what the state was trying to use this for, and that's what they did.
Well, isn't that precisely what any decent lawyer is going to advise their client to do in that situation, not say anything?
Well, that's what defendant came back with. That's what he argued. My lawyers, his lawyers told him not to say anything. That's why, the state can twist any statement he might have made. That's why he was silent. That's why he didn't talk about the civil matters. So defendant was able to rebut this evidence, with his own evidence.
Well, let's go back to the statutory question then. I thought your position on this piece of evidence was that it is admissible because it was not specifically objected to. And because it wasn't specifically objected to, that it can come in.
Well,
And now you're saying that even if it had been objected to, it would have been fruitless because it would have been admissible had the judge actually received an objection.
well, he did.
But isn't that speculative? I mean, we really don't know if Judge Stevens had received an objection and had looked at it, what he would have done.
Well, defendant didn't object on 1-149, and there I'm saying objection on that ground would have been fruitless. He didn't object on relevancy, and again, that would have been fruitless. I don't think everybody at trial recognized that his choosing not to respond to the civil suits affected the credibility of his statement. So relevancy was not objected to. But they did object on Rule 403 grounds. That was their objection, and that's the lens through which this court has to decide this matter. And so you've got to essentially say Judge Stevens was out of his mind in letting this go in. There was no reason at all in his decision. And this court simply can't say that.
Doesn't that bring us back to the statute where manifest disregard of the statute is abuse of discretion? How do you get around that?
I think Judge Stevens knew, like I said, I think the inference is that he knew directly about it.
A record site where we might be certified of your
His instruction is exactly correct, and it jives perfectly with 1-149 and the case law. For example, all the cases, there's 4 cases. There's not a huge body of case law on this, because in 80 years, we have 8 cases. About 4 of them hold the civil matters improper in those cases, and about 4 of them hold the civil matters proper. There's not a whole range. It doesn't cover the whole universe of possible fact scenarios. But McNair, Rowell, Phillips, and Fred D. Wilson are all the cases that say civil matters can come in if the state's purpose for using it is not that impermissible purpose. If its purpose is something else relevant to the case. In those 4 cases, you've got murder cases. You've got the Phillips case, which was a murder case. And so all these civil allegations about the bigamy, you'd think, oh, isn't that scurrilous evidence? No, I mean that can come in. In the Rowell case, it's a homicide case, and a wrongful death suit comes into it, and that's permissible. The defendant was the proponent in that case. Okay, but that was permissible. I would also like to point out that in those 4 cases, McNair, Rowell, Phillips, and Fred D. Wilson, there's no discussion of an instruction given by the court telling the jury how they can use this evidence. And I find that significant because in this case, Judge Stevens sort of went beyond what the case law even had and was giving an instruction. I would also point out that evidence that's admissible for a certain purpose comes into the case. It's incumbent on the party who it hurts to ask for limiting instruction. So technically, it was defendant's duty here to ask for limiting instruction. He didn't do that, but Judge Stevens offered an instruction of his own, and defendant had no problem with it at all. So, in a jury is presumed to follow a court's instructions. And in this case, you've got the instructions to the jury. You are the sole judges of credibility. You are the sole judges of weight. You must find, the defendant is presumed innocent. You must find guilt beyond a reasonable doubt if you are to convict him. Entry of a default judgment has nothing to do with whether it's true or false, and it's not a determination by the court as to guilt. You have to decide guilt beyond a reasonable doubt. It is true that the state let the jury know that it was Judge Stevens who had dealt with one of the civil matters. And I'd like to address that. And what I would say there is that it wasn't the court that let them know. It was the state, which may factor into the analysis. And what the court did say to the jury was the specific instruction and all the specific instructions. So the state's contention there is that there's no improper expression of judicial opinion because you look at this in the totality of the circumstances. That's what the test you apply to that issue. And the charge, where a charge is fair and clear, there's no expression of judicial opinion. I mean, this judge specifically told the jury how it could not, what that civil judgment was not, how it could not be treated. The portion of the trial where this evidence started coming in began to get confused, and I think it is a confusing thing to read, but defense counsel were sort of, what they were doing is they were trying to, and they had planned out, they had thought about this strategy beforehand, and you can see that in the discovery motion, and you can see that in Attorney Klinkison, even in his affidavit in the MAR, and in defendant's MAR at page 17. They had said to themselves, okay, if this civil matter is coming in, we are going to have to respond by discrediting the civil attorneys. That's going to be our task. And that is exactly what they carried out at trial. In fact, they had the clerk read the civil attorney affidavits, which said, we've been practicing for 27 years, and we believe that defendant killed Michelle. It was defendant who read that into evidence, and their purpose, their strategy, was to show that this civil suit, was bogus, that these civil attorneys were poor. They were making these conclusions based on incomplete evidence. They hadn't even seen critical evidence of the SBIs as to fingerprints or shoe prints. They hadn't even seen that stuff, and they're saying this. So they had carefully thought out this strategy. If this comes in, this is how we're going to have to respond to it. That's really our only hope. And they also tried to make the civil attorneys look bad by being greedy, that they collected their $1.1 million and charged for every single little parking stand.
Is it your view that we have all the evidence we need to decide the MAR?
Yes, I do. If you decided in the state's favor, I think you deny the MAR. Now, if you find there's that they actually raise some kind of question, the proper thing would be to dismiss the MAR without prejudice to having a hearing where those attorneys can be questioned. But you can't allow the MAR, and you can deny it, but this court can't simply allow it. The extra things that were admitted, the fact that...
Do you think that it's deficient performance to ignore for a criminal defense attorney to ignore a statute on point in its matter involving criminal evidence and the admission of civil evidence?
I think had they known about this statute, or if they didn't know about this statute, let's put it that way, if they really didn't know about it, had they researched it, it wouldn't have gotten them anywhere because of the case law and because of the plain wording of the statute, frankly. Defendant made the argument that all these contents of the civil pleadings you didn't have to admit. Well, you've got to admit the contents in order to show what it is the defendant is choosing not to answer. And that's the only way you can really get the significance.
Well, how are refusing to answer, how is that an admission? I guess I understand it's an admission civilly, maybe, but how is it an admission criminally?
It's not. It's not, and the state didn't use it. The state didn't use it as such. They simply used it to say, this is why his statement now is incredible. I don't know a ton about civil law, but the statute of limitations was about to run on the wrongful death suit, so I think that's why it was filed then.
That's why you file it and you stay it, so the statute will be told.
Okay. And then there's a question of why were all these materials attached to the motion for entry of default judgment. And I think that is because under Rule 55, a judge, even though he's deciding it based on the default, he might be faced with a motion to set aside the default judgment, which is a pretty low bar. And a judge may want to ask more about the case, even though it is decided on a default basis. I better give my colleagues some time. Thank you.
May it please the court, I'm Amy Irene. I'm an Assistant Attorney General at the Department of Justice, and I'm going to address Argument 4, which deals with the admission of the evidence regarding Cassidy Young's conduct and statements at daycare on November 9th, 2006. I want to initially point out that the state has argued that the defendant did not preserve this issue for appellate review because he did not consistently object at the time the evidence was admitted in front of the jury. And I would simply direct the court's attention to the state's brief on that point, as well as the state's memorandum of additional authority. This evidence was properly admitted at trial because it was non-hearsay. There are two components to the evidence regarding Cassidy Young's conduct and statements at daycare. One, of course, is her conduct of hitting the dolls together with a chair and then putting a doll face down on the dollhouse bed. And then the other component are her statements that mommy's getting a spanking for biting, mommy has boo-boos all over, mommy has red stuff all over. Neither of these components was hearsay because they were not being admitted to show the truth of the matter asserted. In order initially for Cassidy's conduct and statements to be hearsay at all, there would have to be some indication that her conduct was intended by her as an assertion. And there's simply no indication here that that was the case. She was playing spontaneously with dolls at daycare. She was not being asked any questions about her mother's murder or what happened that night. So as to her conduct, there's no indication this was intended as an assertion at all. And then as to both the conduct and the statements together, as I mentioned, there was that evidence was not being used to show the truth of the matter asserted. Instead, both her conduct and her statements were being used for the non-hearsay purpose of showing that she witnessed at least part of the assault on her mother, and that this in turn was relevant to help show that Cassidy was present for some of this attack, but the perpetrator nonetheless chose to leave her unharmed and uninjured. And that was relevant to help show the identity of the perpetrator as being someone who cared about Cassidy and did not want to harm her. The trial court gave the jury a limiting instruction that it could consider this evidence only for that limited non-hearsay purpose of showing that Cassidy, that the jury could consider whether the evidence showed that Cassidy was present for some of the attack. The judge specifically told the jury it could not consider this evidence as assertions of the perpetrator's identity. And the trial court gave that instruction both at the time the evidence was admitted and in the final charge to the jury. So in light of that instruction, this evidence was not coming in for the truth of the matter asserted.
Does it trouble you that the statement was made, the proximity of the statement to the event was different, 6 days? Should we be troubled by that?
No, Your Honor, and I believe your question goes to the issue of if this was hearsay and it was coming in under the excited utterance exception, would that time period be a problem? And of course, defendant has argued that 6 days is too long of a time lapse. And the answer to your question is no, because here we're dealing with a very young child who is 2.5 years old. And our appellate courts have ruled that when dealing with very young children, longer time periods can elapse for the excited utterance exception to still apply, because the stress of the startling event is present in them for longer periods of time than it is in adults. And also our courts have said, I'm sorry, Your Honor.
Go ahead.
Our courts have also said that the characteristics of children make them less likely to fabricate statements for longer periods of time than adults. And I would specifically point you to the State versus Thomas case from this court, where this court said that statements a 5-year-old made 4 to 5 days after sexual abuse occurred were properly admitted under the excited utterance exception. And in this case, we have a 2.5-year-old child, so a child even younger than the child in Thomas. And so her statements made 6 days later should make this statement fall within the excited utterance exception. And that's also true given all of the other circumstances surrounding her conduct and statements, that she was at daycare, she was spontaneously playing with toys, no one was asking her any questions about what had happened. Her teachers testified that she had seemed more withdrawn than usual that week, not her social self. Looking at all of the circumstances in which this conduct and the statements occurred, this would qualify under the excited utterance exception.
We review this under an abuse of discretion standard, don't we?
Your Honor,
It's objected to, wasn't it? So it would be a legal standard.
Your Honor, I believe the court's Rule 403 determination is abuse of discretion, as you said, and then I believe the ultimate decision of is this an excited utterance would probably be de novo. And I do want to...
I'm just having a little trouble with the why this proves the identity of the person. I mean, if obviously the child knew that its mother was dead, and it's, so I'm just having a little trouble understanding how it leads to the conclusion. Any inference can be drawn as to whether or not about the identity of the assailant here, but I guess it's a question of discretion in that regard.
Your Honor, the reason why it's relevant to help show the identity, these were not direct assertions of Cassidy saying who did it. And in fact, the judge told the jury, you can't consider these as direct assertions of who did it. But it is relevant to help show the identity of the perpetrator because it shows that Cassidy Young was in the house at the time this attack was occurring, and the perpetrator chose not to eliminate her as a possible witness.
Well, it could show that. I mean, it's certainly highly ambiguous evidence.
Well, Your Honor, it was certainly up to the jury to decide what weight they want to give to the evidence. But in terms of making the initial relevancy threshold determination, the judge is given great deference in making a relevancy determination. Our appellate courts have said that. The trial court is giving great deference on relevancy. And so that evidence was relevant to help show the identity of the perpetrator. Judge Hunter, you had asked a question about her competency, and I did want to just briefly point out that Cassidy's competency as a witness is not something that has been raised on appeal, and so that is not before you. But the State versus Rogers case that's cited in the State's brief dealt with a situation where the child declarant was ruled to be incompetent as a witness, but her out-of-court statement was properly admitted under the excited utterance exception. So I did want to direct your attention to that case on that point. And I have not researched that issue further since it has not been raised on appeal.
But now, if it's not hearsay, excited utterance doesn't matter, does it?
That's correct, Your Honor. Yes. So State's arguing you don't need to reach this excited utterance issue at all because this was non-hearsay.
She's not really a declarant, I guess, because there's no statement that I'm trying to introduce first.
Right. The conduct in the statements were coming in for non-hearsay purposes, and so there's no need to get to the excited utterance exception at all. I do want to point out that if the court thought that some or all of this evidence about Cassidy's conduct and statements was improperly admitted, the error would be harmless because of the other evidence in the case that showed she was present but was not harmed by the perpetrator. That evidence included the evidence of the child-sized bloody footprints in the master bedroom, on the landing, and in Cassidy's bathroom, the blood smears at a child's level in Cassidy's bathroom. Those photographs showing that have been transmitted to this court for you to look at. You can see from those that she must have had a considerable amount of blood on her at some point, but was cleaned of the blood by the perpetrator before he left, and this helps show that the perpetrator was someone who did not want to harm Cassidy and did not want to eliminate her as a witness. And in this regard, it helps show that the perpetrator was the defendant, not a stranger. The defendant has today made mention briefly of the sufficiency of the evidence, and I did want to briefly address that. Of course, this court must view the evidence in the light most favorable to the state, and I'll draw all reasonable inferences in the state's favor. Here, the state presented sufficient evidence of the defendant's identity as the perpetrator of this murder. The defendant and Michelle Young's marriage was in shambles. The defendant had slept with 2 different women in the weeks leading up to his wife's murder. The camera at the Hampton Inn where the defendant checked in and claimed he was the night of his wife's murder was tampered with twice. The emergency exit door at the Hampton Inn was propped open that same night. The defendant was identified by an eyewitness as being at a gas station in King, North Carolina at 5:30 a.m. on November 3rd. That was on the most direct route if you were driving from Raleigh back to the Hampton Inn, and it was at a time consistent with the defendant driving back after having killed his wife. There were footwear impressions in blood found in the crime scene that corresponded with size 12 orbitals. There was evidence that the defendant owned a pair of size 12 orbitals. The Cracker Barrel surveillance footage showed him wearing shoes that were consistent with orbitals. His orbitals were never recovered, and a reasonable inference is that he disposed of them after he murdered his wife. Defendant was shown on Hampton Inn surveillance video at the front desk shortly before midnight wearing a dark shirt with a horizontal stripe on it. That shirt was not in his luggage, it was not in his car, and it has never been found. A reasonable inference is that he disposed of the shirt after wearing it to murder his wife. There were many facts that showed that this murder was not committed by a stranger. There was no forced entry, the house was not ransacked, electronics in plain view in the house were not stolen, Michelle Young's purse, keys, and Lexus were not stolen, she was not sexually assaulted, she suffered an excessively brutal beating with over 30 distinct blows, showing that this was someone who was personally enraged with her. Cassidy was not harmed or eliminated as a witness. All of these circumstances show that this was not a stranger, it was the defendant who killed his wife. The state presented sufficient evidence of his identity. The trial court properly denied the motions to dismiss and sent this case to the jury for the jury to resolve. The state asks that this court find no error.
You still have, I think, 10 minutes left.
The state urged this court to carefully review the McNair case, and I urge you to review it as well. In that particular case, the prosecutor informed the trial court that he was going to introduce evidence of a civil complaint as impeachment. In this case, the prosecutor made no representation to the court as to why the evidence was being admitted. The prosecutor in the McNair case actually felt that the civil case, which had been authored by the defendant, was untrue. So clearly, Section 1149 was not coming into play because it wasn't being used to prove the truth of the allegation. In fact, it was being used to point out that the defendant made one set of statements in the complaint he authored, another set of statements in trial, and both were being admitted as proper impeachment evidence. Regarding the notion that counsel made strategic decision-making here, when you approach a problem as, how do we mitigate the damage of evidence coming in, rather than saying, are there any statutes or rules of evidence or cases that bear on the admissibility of this type of evidence, you're really putting the cart before the horse, and that's what happened here. And so they came up with this strategy, completely unaware of the relevant case law and statutes, that they need to attack the credibility of non-testifying civil attorneys. Well, their credibility is clearly not at issue in this case. Their credibility doesn't make any fact more probable than not. So the strategy that's adopted doesn't make any particular sense. And we see that because of the lack of research that was done. Had they done even the most rudimentary research, they would run into Wilson, holding that admission of a civil default is, in fact, proof of the matters asserted or admitted and a violation of 149. As to the Cassidy hearsay statements, I think the state is making out an assertion to be far more formal a matter than it actually is. An assertion is simply a declaration. And that is what we have here. And I don't read the instruction that the court gave as telling the jury, you are utilizing this for non-hearsay purposes. What the court was telling the jury is, if you understand from that statement that she was an eyewitness to the murder, because again, we've got language consistent with a 2.5-year-old that may not be how an adult would describe the incident viewed, then you may do X with that evidence. So I think it's a misstatement to characterize the instruction given on that hearsay in that way. So for all of the reasons given in the brief, we would ask for vacation of the conviction or new trial. Thank you.
Thank you. We'll take a brief recess, about 5 minutes between cases so everybody can get rearranged. So.
All rise.